Jerry is Josepha Madigan. We have free legal advice today. Josepha is back with us again. We're thrilled with that. She's a family law expert and a solicitor. And of course, there's a new family law bill, which we'll talk about a little bit later on. So I suppose when people come into you, Josepha, what are the main worries they have when you face family law? Because it's a very contentious area.
It is, and I suppose for most people it's their children more that they would be concerned about. You know, whatever the circumstances of a marital breakdown, or indeed even a relationship, whether it's civil partnership or cohabitance or whatever, they want to know, are they still going to see their children as much, you know, as when they were married or not, particularly if one is to leave the place that they're living in. So I would say children's probably the biggest question.
Yeah.
After that, probably how much they'll have to pay. You know, either their spouse, or the children.
How much can I get?
Exactly, there's that too. So obviously the finances is a big one also.
And I guess it's changing all the time for you in family law, with people marrying people from other countries, children being brought out of the jurisdiction, the issues of bringing them back, that type of thing as well. We actually have questions even on that already, if a relationship breaks down and one of the partners moved to a different country, and how, you know, that the family, can they see the children again or even get them back? So we'll discuss all that. So do get your questions in for Josepha today. Now I'm joined by Josepha Madigan, who is solicitor and family law expert. And today we're talking about family law and about a lot of issues surrounding family law. And Josepha, you're welcome. I guess the real issue here is, I suppose, we see a new bill coming in to effect now since yesterday. But we'll talk about that a little bit later on. But the main issues are guardianship of children, probably, if there are children within the family.
Yeah, I suppose it's access to children, you know, and I suppose we have to put it in context when we're talking about children at all, and think about their best interests. You know, if you think of the UN Convention of the Rights of the Child, you know, it's about the best interests of the children. So whether somebody is looking for custody to a child, access to a child, or whatever the circumstances are, that's the overriding tenet that has to be established. Yeah, exactly. And the Guardianship of Infants Act, which is before this new Children Family Relationships Bill, talks about taking into account the social, intellectual, moral, religious, and even the courts have now brought in the emotional interests of the child. So all of those things have to be taken into account.
Okay,
you know?
And this is as it goes to court. The new Act, just to touch on it, it changes things a little bit, because it was always the case that the mother got the child, normally, in a court situation. That's changed slightly now, that fathers seem to be given more rights.
They have, and yeah, it goes back really to the tender principles. I think it was the tender
mother being the nurturer.
Exactly, the mother being the nurturer of the children, and was usually established as the primary care because she would have been at home with the children. But that sort of has been diluted somewhat over the years, you know. Now, fathers, for the first time ever, are given automatic guardianship rights, which is really amazing. And, you know, obviously they have to have lived with the child's mother for a consecutive 12-month period, and at least 3 months after the birth of the child. But I mean, before this, fathers, you know, had no automatic guardianship rights. So in a sense, I think the Act is really bringing into effect the diverse family forms that we already have throughout Ireland, and how we've changed so much. I mean, going back to the 1937 Constitution, it was just a husband and wife and a child.
And goodbye.
Exactly. And now...
And the wife was at home and the husband went out to work.
Exactly. And it's changed so much more. I mean, you know, I think that the decline in the marital breakdown, or the married people getting married, is like 40% since the 1970s.
Different types of families.
So there's different types of families, and, you know, there's IVF, and there are...
Well, there are issues that haven't been dealt with, I suppose, yet.
Exactly.
And the thing of, I suppose, surrogacy and all that, which is down the road and yet to come. Josepha's going to stay with us. We're going to talk a lot more after the break. We've got a lot of questions coming in, a lot of issues on maintenance as well, a lot of issues on as you said here, on guardianship and custody, and we'll discuss that with Josepha after the break. Louise Herity as well will be with us with our VHI fitness programme. We'll see you in a minute. Now, the aftermath of relationship breakdowns and issues regarding maintenance, guardianship and custody and access can be very difficult to understand. Now, here to help us navigate through the complexities of family law and also to answer some of your questions is family law expert and solicitor Josepha Madigan. Hello.
Hello.
Again. Now, Josepha, thank you for staying with us. Remind us again of the new Act that has just come in, because people will not really know what's in this, but I suppose give us a synopsis of what's changed in the new Children and Family Relations Act that's just been signed into law.
Okay, so to put it very simply, maybe the most important part is in relation to unmarried fathers. So they now have automatic guardianship to their children once they have been living with the mother for 12 months consecutively and 3 months after the birth. Same-sex couples, then the partner to the parent can now apply for either guardianship or custody once they have been living together with the other person for at least 3 years, and they have been acting in locus parentis, which means co-parenting the child for at least 2 years.
And they're obviously not the biological parent.
Exactly.
And they can still apply. So that's very new, and that's a big
that wasn't dealt with before more in the previous legislation. And then grandparents, as it stands, up until yesterday, grandparents had to apply for leave to court to apply. So now they can apply directly. So it's no longer a two-pronged approach. So it's much simpler. And I think this legislation has been, welcomed overall, and it just reflects the changing diverse family units, as we mentioned earlier.
But what about unmarried fathers who haven't been living with their partners? What situation are they in?
Well, they're not automatic guardians, Dahi. So
a lot of people a lot of men would say that hasn't gone far enough for them.
Yeah. Well, not really, because they can apply, certainly, if they can prove the thing. But the reality is...
But they're saying is, if you're the father, you're the father. That's what they'd be saying.
Automatic, yeah. And even if they're on the birth cert, they're not automatic guardians. I mean, even this legislation, it just simply allows people to apply, but doesn't necessarily mean that you'll get it.
Okay.
And any father of a child can always apply for guardianship. The courts are very pro-fathers in that sense. And obviously access that they would have if they weren't the primary carer of the child, So...
I suppose the courts always have to look as well, as you said, the primary issue here is the child, and that the child is taken care of the proper way. And if a child was a result of, say, a one-night stand or something even more awful that we'd hate to think of right now, in a case like that automatic guardianship in those cases wouldn't be the proper way.
I mean, guardianship is actually the right of the child at the end of the day. It's all about the best interests of the child. It's the paramount consideration. It supersedes the rights of any parents at the end of the day. So it's all about them. And this legislation also provides that the voice of the child will be heard also.
Which is so important.
Which is so important. But although judges don't have to take into account what they can take it into account, but they don't necessarily have to go with what the child wants, obviously.
I suppose we've seen that, though, in family law cases, although they're always held in camera, so it's very difficult to actually, that you can't print the names or that type of thing, and it's not often reported. But we've seen judges listen to children in courts, and at a certain age that the child can actually have their voice and say, I'd like to live with X or Y, or that type of thing.
Yes, exactly. And even the children's referendum, I think the voice of the child was age 12.
Yeah.
I mean, we can get what they call Section 47 reports in the Circuit Court if there's a major dispute about access, or because judges at the end of the day aren't child psychologists either. And having one parent pitted against the other, they're going to think that they're the ones who know the best interest.
The judges probably look at the law as well. This is the law. The law can be black and white, and
exactly, and all the factors have to be taken into account. At the end of the day.
Let's get to some of the questions. A lot coming in, a lot on custody as well. My brother passed away 6 months ago. His wife won't let their children have any contact with any of our family. We miss the children dearly. It's bad enough losing my brother, but it's twice as bad losing his children too. What visitation rights have we got for access to his children? Now, it didn't say who this is. It's a family member.
Okay, yeah, it's very tough for that person. I mean, one of the fabulous things about this new piece of legislation, the Children Family Relationships Bill, is that it's extended relatives also, not just grandparents, who can apply to the court. Now, I'm not saying that they'll get access, but obviously if they can prove to the court that it's in the best interest of those children that they see their aunts and uncles, well, then I'm sure that
this is by no means anything automatic at all. It's just this process is there now. This is how you go about it.
Exactly.
Okay, but there's nothing guaranteed at the end of the day. It's down to the judge to say yes or no.
Exactly, and each case will depend on its own facts, obviously.
There's another one here. I separated from my alcoholic, verbal abusive husband 20 months ago. We have 3 grown-up children. I'm in cancer treatment at the moment. My question is, could I get spousal maintenance from him as he lives in the family home and owns land? I don't want to sell the family home or land as it's my children's inheritance.
It's tough, isn't it?
Very tough.
Yeah, and the difficulty, there's a few layers to that question. First of all, I would say to go to get independent legal advice. I mean, it shouldn't cost an awful lot to have a consultation with a private solicitor or indeed the legal aid board. If you might even be interested in mediation. But children, and this sort of goes a bit into probate law, but children don't have an automatic right to a parent's estate in terms of I think she's saying that she wants to protect the inheritance for her sons.
Yes, so she doesn't want to sell the family home or the land.
Well, if he was to leave a will, for example, Dahi, and she would be entitled to a legal right share, but the children may get nothing. So by doing nothing, she's not benefiting anybody. So really she should get legal advice.
But they're married here, and they said that he's in the family home and he owns the land. If they're married surely to God, she has 50% of it.
Well, that's the rule of thumb. I mean, in this jurisdiction, both parties are entitled to 50%, and if either party wants more, they have to prove to the court why they should get more. But certainly, she'd be entitled to spousal maintenance. I would have thought.
She's out of the family home, though, as she said. She's obviously having cancer treatment elsewhere. He's in the family home. She is entitled to maintenance anyway. So she'd have to start with the district court and go upwards. Is that the way she
Absolutely.
should go?
I mean, I think if they've broken up, I would suggest she go for a judicial separation.
Absolutely, first.
You know, or separation deed if she can go through mediation that way. But certainly she should do nothing, because I know her heart's in the right place and she wants to protect that property for her children. But really, she needs to sort that out.
But she hasn't applied to any spousal maintenance, so she's entitled. This is very interesting. I think the way, as you said, it reflects the new law in this country, the way things are changing, the family is changing, but also, I suppose, as a society, how we're changing and how we're living in different parts of the world and marrying different people. This is interesting. I was living in New Zealand with my partner and New Zealand-born son. My partner, now my ex, went back to Ireland on holiday with my son. She isn't coming back. Now, both these people are Irish, actually. So it's a long story. She said, I returned to get to see my son, and although I do see my son regularly, after much negotiation, all the decision-making seems to lie with her, as she has appointed herself primary carer. Advice, please. We're both Irish, but our son is New Zealand-born. I've lived a fair portion of my life in New Zealand, and now it's turned on its head. So basically, he is saying, what is the situation
And he's
here?
writing from New Zealand.
Yes.
Yeah, and the child, I think it sounds like the child's habitually resident in New Zealand. So
The child is now habitually, yes, but the child has now been brought to Ireland.
Brought to Ireland, yeah, it's going to be difficult. I think he would have to institute proceedings probably in New Zealand and under the Hague Convention, try and bring the child back, because obviously the child was habitually resident in New Zealand at some point. The difficulty with it is that litigation, as you know, it can take a long time to go through the courts, and by the time it reaches the court, the child may well have established that its habitual residence is in Ireland. But certainly he should get legal advice.
It's a very
in New
long
Zealand
road
about
ahead.
Could be a long road.
How long would something like that take, though, the reality if a child, because an awful lot of what we're seeing, and I'm sure you're seeing, and I'm sure you're dealing in cases, is that children are being taken out of the country without but one of the guardians' consent.
But that's child abduction more, really,
that's child abduction.
Is the bottom line about that. And really, we have seen, particularly over the recession, a lot of relocation applications where one party has looked for the consent of the court to go to another jurisdiction. But if somebody just up sticks and takes their child to somewhere else, under the Hague Convention, that's protected. You know, we should be able to bring the child back to this
Just want to get
jurisdiction.
one more here. My brother separated from his wife in December. They have a son aged 2. His wife is from Poland and she is planning to bring their son on holiday to visit her parents this summer. When they initially split, his wife said that she wanted to move home for good. So my parents are very concerned. If she decides not to return with their son, has my brother any rights? It's the same type of thing again.
But if he has concerns, what I would suggest is that he goes into the court and not necessarily restrain her from going to Poland, but put parameters in place. I mean, within Europe, we have protections, and you know, and we can talk to other jurisdictions just to put his mind at ease. Because once the child is gone, it's more difficult to get the child back.
So basically, if the child goes and is not being allowed to come back to Ireland, can he get the child back?
Oh, he can, and he should under the Hague Convention. But I suppose what I'm saying is, to stop that even happening in the first instance, he should either speak to her about it or go into court.
But what kind of parameters can you put in place?
But there are protections that can be put in place. So the Irish authorities would notify the Polish authorities
if the passport
and let
shows
them
up
know
at the
that they're
airport.
there, you know, and all of that. And
should he tell her that this is happening?
Yeah, I think he's consented to her leaving. Was my understanding. You know?
Okay.
So if he's consenting, he can't really do anything until she's actually breached.
She's gone.
And she's gone, and she's refusing to come back. So what I would say is to go into court in the first instance, if in the absence of an agreement between them. If he does have concerns and he's not sure that she will bring the child back, you know.
Do that.
Josepha, thank you
thank
very
you
much.
so much. Again, its time has gone far too fast, and we need to return to this, I think, certainly, because we have so many questions we didn't get through here. Thank you, Josepha.
Not at all, my pleasure.